Hello, everyone. Welcome. My name is Kevin Swain, and I serve as the Events Director for the Buckley program. Today, I have the pleasure of introducing Yale professor Carlos Eire, who will be moderating our first panel, Challenges to Religious Liberty in 21st Century America. At age 11, Carlos Eire, unaccompanied, fled Cuba to come to the United States. He received a BA in History and Theology from Loyola University Chicago in 1973 and a PhD from Yale in 1979. Professor Eire specializes in the social, intellectual, religious, and cultural history of late medieval and early modern Europe. He has authored numerous books, including Waiting for Snow in Havana, which won the National Book Award for Nonfiction in 2003. A past president of the Society for Reformation Research, Professor Eire's work has had a strong focus on both the Protestant and Catholic Reformations, the history of popular piety, the supernatural, and death. In Cuba, he has been proclaimed an enemy of the state, which he regards as a high honor. Please join me in welcoming Professor Carlos Eire.
Thank you. It's great to be here. It's a great honor and privilege. Every now and then I teach a freshman seminar entitled Essential Heresies. And we cover 10 big heresies, some good, some not so good. But I always begin with one book, one great heresy. William F. Buckley's God and Man at Yale. And I'm a little bit out of my element here because if anything happened after 1650, I generally don't know about it, unless it influenced me. But we're celebrating the 500th anniversary of the beginning of the Protestant Reformation this year. And there's a link here, I believe, between my professional expertise and what's going on in two ways. One is religious liberty did not exist in 1517. It took a long time, and it was a very painful, very bloody, and very violent process through which Western civilization arrived at the actual practice of religious toleration and of observing religious liberty. Very painful, very bloody, and it remains very, very fragile. My other connection is, of course, having lived in Cuba in a totalitarian regime where Marxist ideology is the only religion allowed, basically, and there is no true religious liberty, which makes me all the more conscious of the fragility of the religious liberty that we enjoy in this blessed country. So it's an honor and a privilege, even though I'm way, way out of my field and feel pretty much like perhaps my freshmen do when they come to the freshman seminar. But I'd like to just point out to you, we're going to have about 10-minute presentations from each of our panelists, and then we'll open it for questions. Our first panelist, Mollie Hemingway, is a journalist and political commentator and is currently a senior editor at the online magazine The Federalist and a contributor to Fox News as of March 2017. Previously, her work has appeared in publications of all sorts, including the Wall Street Journal, USA Today, the Los Angeles Times, The Guardian, Washington Post, CNN, Real Clear Politics, National Review, and Christianity Today. Without further ado, please welcome Mollie Hemingway.
Okay, and I'll just stay here. Thanks, it's great to be here with you. And I'm Lutheran, so I've just gone through a crazy week of partying for the 500th anniversary. Concerts, I had a big house gathering and whatnot. But we're talking about threats to religious liberty in the 21st century. And I assume my co-panelists will be focused more on the legal questions. It's my view that our legal framework is actually quite strong, but that our cultural framework is weak. Last week I heard Rabbi Lord Sachs speak about how the way he put it was that the Declaration is sort of our social covenant and the Constitution is our social contract. And we couldn't have better religious liberty protections in law. There's this aspect of the social contract, the social covenant that I believe that we are losing out on. 2 years ago, the deputy legal director at the ACLU wrote an op-ed at the Washington Post announcing that the ACLU would no longer support federal religious freedom laws. They had been an early supporter of the Religious Freedom Restoration Act, and this was just an alarming turnabout for a group that ostensibly cares about civil liberties. Just real quick on the federal legislation that was passed in the early 90s came after there was a Supreme Court ruling that went against two Native American religious practitioners. They'd lost their job for smoking peyote, and then it was a federal job, and then they were ineligible for unemployment benefits. Went to the Supreme Court, they lost, and this really alarmed.
In an opinion by that heretical secular transhumanist Nino Scalia.
Was written by Scalia. I was trying to avoid, bringing that up, but a rare miss. But this really alarmed people across the religious and civil liberty spectrum. And you got this broad coalition, people like the ACLU, as well as Traditional Values Coalition, Christian Legal Society, American Jewish Congress. They all worked together with the National Association of Evangelicals. Just pretty much everybody came up with this legislation that reinstated what's called the Sherbert test. It's basically, what it means is not that if you have a conflict between federal law and your religious liberty that you automatically win. It just provides a framework for hashing it out in the courts. And it passed overwhelmingly. I mean, it was passed the Senate 97-3, signed into law by Bill Clinton, just really popular legislation. It's been used by hundreds of different religious groups and individuals as they battle the feds when there is a conflict between some federal law and religious liberty. It was actually what was used by the Little Sisters of the Poor and it continues to be used by them as in their continued battle against the federal government. But because a Christian business was able to use the Religious Freedom Restoration Act that the ACLU helped pass, the ACLU decided, and this was kind of in the op-ed, we liked this when it was able to be used by religious minorities such as peyote-smoking Native American religious groups. We don't feel so comfortable now that it's used by Christian business owners to practice their religion in this country. What was alarming to me about this whole thing, though, was not just the ACLU, but this larger way that we talk about it. I focus on media criticism, so in all of the cultural onslaught against religious liberty, I have been paying a lot of attention to the way the media cover these issues. They cover them horribly. I mean, it's absolutely horrible the way the media cover this foundational freedom of ours. I think it's best evidenced by the way a few years ago the media started putting religious liberty in scare quotes. It's like it's in the First Amendment. You don't really need to scare quote this this basic thing. But I also don't think that journalists understand how religious liberty is important for freedom of the press. There was a famous case in 1735. It's not so important legally, but it's important sort of to the culture of the country, the John Peter Zenger trial. Maybe like me, you got to play the part of the publisher in the 5th grade play on the John Peter Zenger trial. We know it mostly for this idea that truth can be admitted as a defense. But the entire thing, what was happening was they were publishing these Cato's letters, which dealt a lot with religious liberty, and this idea that the government cannot control or dictate what people believe. And it was just entirely a disputation on truth and how truth is revealed to man, and whether people have the right to determine truth and have the right to go about finding out what is true about God without government interference. And of course now if you believe that you have the right to go about finding out these things and practicing your religion, you are called a bigot by people, and by people in the media, now 300 years later. And they seem to just work actively to suppress this idea. They redefine these religious liberty bills, these religious freedom restoration acts, which states also started passing them because the Religious Freedom Restoration Act at the federal level doesn't apply to the states. So states were passing them and moderating or amending them and whatnot. And when they did this, like a couple years ago, they started calling these bills freedom to discriminate bills or anti-gay bills. Because even though I don't think Religious Freedom Restoration Act has been used like in a single case involving gay issues, it potentially could be, so they were calling it anti-gay legislation. We have this conflict right now between sexual liberty and religious liberty. And throughout our history, we've had conflicts between religious liberty and other values that we hold. Chai Feldblum, who is an EEOC director, is she currently or former? Not anymore. She once said that she couldn't think of a single instance where sexual liberty and religious liberty are in conflict where religious liberty should win. That kind of thinking is so dangerous. We have these great laws, but when people who are, in these, in different administrative positions or otherwise, or legal positions, when they don't actually understand, when they don't practice this, when they don't understand the history or how important it is, that to me is a very big threat that we should be worried about. I believe a media less hostile to religious liberty would think less about treating this as like a partisan or political issue and understanding the importance to all of us, whether we're believers or non-believers, to the fabric of our society, to civil discourse between people. If we're going to be a pluralistic society, if we're going to have people with different beliefs, we have to have a strong view here. And also, it's just so important because religious liberty is the canary in the coal mine for so many other issues, not just freedom of the press, which is actually sort of built on this idea of whether you can find your own way to truth, but also freedom of speech, freedom of assembly, and so many other things that we hold dear. So when the media or other people attack religious liberty, I don't think they're thinking through what the long-term consequences of those are. And that is all I had to say.
Great. And of course, we'll save questions till all the panelists have spoken. Our next panelist is Michael W. McConnell, the Richard Francis Mallory Professor and Director of Constitutional Law Center at Stanford Law School, and a Senior Fellow at the Hoover Institution. From 2002 to the summer of 2009, he served as Circuit Judge on the United States Court of Appeals for the 10th Circuit. He has held chaired professorships at the University of Chicago and the University of Utah and visiting professors at Harvard and NYU. And he has published widely in the fields of constitutional law and theory, especially church and state, equal protection. And one amazing fact, in the past decade, his work has been cited in opinions of the Supreme Court second most often of any legal scholar.
Nice.
He is co-editor of 3 books, Religion and the Law, Christian Perspectives on Legal Thought, and the Constitution of the United States. He has argued 15 cases in the Supreme Court and has served as law clerk to Supreme Court Justice William Brennan. Professor McConnell.
Thank you very much, and thanks for having me here. I was also a great admirer of William F. Buckley, met him on 2 occasions, and could tell some stories, but that's not what I'm here for. So I'm going to be sort of the yin to Mollie's yang. I want to say, for a journalist, that was a remarkably accurate portrayal. This was not, this is a very dire picture that Mollie painted, but I can't correct it or ameliorate it in any way. It's exactly as she has as she said. But I want to pick up on her first sentence, which is that the legal protections are actually quite strong, and that's what I'm going to talk about. So I'm sort of the happy face on a panel about the threats, because the United States Supreme Court has been actually remarkably good on the subject of religious freedom over the last, say, decade or so. And not only have they been good, but they've been getting better. So the trend has been quite excellent. I want to talk about several different developments here, and then maybe a little more pessimism at the end. So one matter is, as you probably know, the First Amendment has a religion clause which has two different parts. It has a free exercise part that protects every person's right of free exercise of religion, and also the Establishment Clause, which forbids any law respecting an establishment of religion. That latter part is often called, somewhat inaccurately, the separation between church and state. And many people think, and the Supreme Court used to say, that these two clauses are in tension with each other, that the first powerfully protects religious freedom, but that the second is a restraint on the role of religion in public life. Now, this is not a lecture on that topic. Let me just say I think that is a piffle when it comes to any historical understanding of those clauses. It's just not so, but nonetheless, very common view. When I first started practicing in this area, it was still a pretty dominant view. Well, the Supreme Court has been taking quite a fresh look at the Establishment Clause and recognizing that, in fact, what the Establishment Clause is really about is a government control over religion. And the Establishment Clause was urged not by anti-religious Enlightenment secularists, but rather it was championed by the most evangelical forces in American religious life. It's designed to protect religion just in a slightly different way from the Free Exercise Clause. And in particular, the Supreme Court used to believe that the Establishment Clause prohibited any kind of assistance to, aid to religion, even pursuant to an entirely neutral program. And if that is the law, the implication of that is that religious institutions must be affirmatively discriminated against. That is, you have a neutral aid program, like, say, a voucher program for education, and the court used to say that religious institutions were constitutionally excluded from that. Well, the Supreme Court has dramatically abandoned that doctrine. First, in the Cleveland voucher case, in which the court said that it is permissible, it doesn't violate the Constitution, to include religiously affiliated schools among a broad neutral program of that sort. And then most recently, just last term, in a case called Trinity Lutheran Church, the court actually held that it is unconstitutional to exclude religious institutions solely because of their religious status. So the court has gone from this this view that the Constitution compels discrimination against religious institutions as such, to the view that the Constitution compels neutrality toward religious institutions. And that is a huge change. Now, a lot of that has to do with aid programs and government and in general, but it's important beyond just the just things like vouchers and government money, because the underlying philosophy of the old view of the Establishment Clause was one in which religion was kind of a bad thing that had to be kept at arm's length, right? And the new, and I think more accurate view of the Establishment Clause is one of what the court sometimes calls benevolent neutrality. That is, religion does not have a preferred place in our public life, but it's also not to be held at arm's length. As a court said decades and decades ago, religion in the United States shall flourish according to the appeal of the zeal of its adherents and the appeal of its dogma. That is, we Americans get to decide for ourselves how much religion we're going to have in our public life. The government isn't going to decide it for us. This has been very important and one of the most dramatic shifts in doctrine on the Supreme Court in the last 25 years. Now, what about the subject of more individual religious freedom? Looked pretty bad at the time of Justice Scalia's opinion in Employment Against Smith, Division Against Smith, with the so-called peyote case. And I was among those people who were, tearing out our hair and complaining to Congress at the time. But Congress did pass the Religious Freedom Restoration Act, and it has made a difference. Now, at the time, I thought, I'd rather have constitutional protection. The statute, that's second class. I'd rather have, the Constitution protecting this. I actually, as a practical matter, maybe that would be true symbolically still, but as a practical matter, it has worked the other way. The Religious Freedom Restoration Act is a much more effective tool for litigators to win religious freedom victories than the Free Exercise Clause ever was. And the reason for that, which I didn't appreciate at the time, but is so clear now, is that in a constitutional case, when the judge decides that a particular law or government practice violates the Free Exercise Clause, they're saying that's forever, that's the Constitution, and the Democratic branches, it's overturning the decision of the Democratic branches. And judges are rightly, a bit restrained, a little reluctant to do that. Now, under the Religious Freedom Restoration Act, Congress can change it if they want to, so the courts feel less, the stakes are a little bit lower, and it's one Democratic statute against another, so there's no longer this sort of psychological barrier of worrying about judicial activism. Now it's like this is a statute, and they enforce it in full force. But also, in addition to the Religious Freedom Restoration Act, which, by the way, I should say, it was the constitutionality of it was challenged. A lot of people, said, "Oh, this violates the Establishment Clause because it favors religion," right? Unanimously rejected by the Supreme Court in an opinion by none other than Justice Ruth Bader Ginsburg. So the constitutionality of this statute, these statutes that are now so derided by the press, unanimously held to be constitutional. And in addition to that, even the Free Exercise Clause, which looked like it was in tatters after Employment Division Against Smith, has been revived, and in certain important areas. Since Smith, there have been two important free exercise cases, one of them a unanimous holding that churches have a right to choose their own clergy. This held unconstitutional an employment discrimination statute, a civil rights statute, which is, if we now have a national religion in America, it's anti-discrimination, but the court held that the Free Exercise Clause even creates an exception on behalf of churches being able to govern themselves through hiring their own clergy. So since John Roberts has been Chief Justice, and this isn't about him personally, but it's just to give a time period, the Supreme Court has, in religion cases, they have decided in favor of the religious freedom claimant in every single one except one. That was Christian Legal Society against Hastings Law School, and we can scratch that one up to incompetent legal counsel in the Supreme Court. I represented Christian Legal Society in that case. It still rankles. But other than that case, the religious freedom side has won it. And it has been either unanimous or nearly unanimous in all of those but one, that one being the Hobby Lobby case, which, I have to admit that was a hard case, for-profit corporation, right? I can see why some people, I sided with Hobby Lobby and wrote a brief, but I can understand why some people find it a little difficult to understand how a for-profit corporation can be exercising a religion. So it was a genuinely hard case, 5-4. The Little Sisters of the Poor case, which was also a challenge to the contraceptive mandate under Obamacare, but on behalf of religious organizations, in the end was unanimous in favor, almost entirely in favor of the Little Sisters. No opinion, unfortunately, but the Little Sisters won. And so here's the pessimistic note. So the Supreme Court has been great, really excellent on these issues. Lower courts, not so much. Many of the decisions I've mentioned, even many of the unanimous decisions I've mentioned, I think almost all of them even, were reversing lower court decisions. The lower courts in this country are not on board with religious liberty, and they are not particularly reading the signals from the Supreme Court either. The Little Sisters, for example,
well, we have more judges being confirmed this week.
It'll get better. Yeah. It will get better, and it could have gotten a lot worse had Providence gone the other way. Just one last, I realize my time is up, but this is, I think, an interesting point. In the Little Sisters case, as the case came to the Supreme Court, there have been decisions from, I think, 7 different courts of appeals. I may have the number off by one. Every single decision at that point had gone against the Little Sisters, most of them holding that there was no cognizable burden on the free exercise rights of these organizations when they were being told to cover a contraceptive in their health care plans. Supreme Court. So when the Supreme Court decided this without dissent, they were effectively reversing every single court of appeals that had touched the question. And this is by no means the only case where you see that happening. So that's a cautionary note. And frankly, the cultural side of this should not be overlooked for the legal purpose too, because the Supreme Court is what it is. A bunch of old people, right? They reflect the views, the more civil libertarian views that were much more commonly taught to conservatives and liberals alike a generation ago. And law school is very different today. It is much more reflective of the cultural identity politics influences that Mollie was talking about. Those are going to be the law clerks and judges of not the immediate future, we know, but of the more future, and that could be a very different story.
Our next presenter is Ilya Shapiro, a senior fellow in constitutional studies at the Cato Institute and editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was a special assistant advisor to the multinational force in Iraq on rule of law issues. He is the co-author of Religious Liberties for Corporations, ? Hobby Lobby, the Affordable Care Act, and the Constitution, published in 2014. He is a contributor to a variety of academic and popular and professional publications, including the Wall Street Journal, Harvard Journal of Law and Public Policy, the Los Angeles Times, USA Today, the Weekly Standard, New York Times Online, and National Review Online. He also regularly provides commentary for various media outlets, including CNN, Fox News, ABC, CBS, NBC, Univision, and Telemundo, The Colbert Report, and NPR.
No Pravda?
Actually, I do Russian language interviews for Radio Free Europe and Voice of America, so yeah. And on that note, it's an honor to be here, not just with Mollie and Michael, but with Professor Eire. I was just telling him before the conference began that I emailed him about a decade ago when I had read his wonderful book, Waiting for Snow in Havana, which I recommend heartily. Great memoir of his immigrant experience, and it resonated with me because I'm also an immigrant, twice over actually, from the Soviet Union to Canada. To here, the damn socialism keeps following me around. But like most immigrants, I do a job that native-born Americans won't, and that's defending the Constitution. I'm also delighted to be here, part of the Buckley program. I certainly held Mr. Buckley in high regard. As a Princeton man, however, I'm also glad that this event is being held at a hotel, not on campus at the dark place, right? But although I will note that I've gotten this invitation, which I'm grateful for, but I have not yet been invited to speak to Princeton's Madison program, so maybe I'll have to cajole Robbie George next time. And I'm also, like Judge Pryor, a longtime National Review subscriber and an inaugural National Review Institute Washington Fellow. So I'm deeply ensconced in this kind of fusionist or classical liberal sort of orientation. And maybe that's why I'm everybody's favorite libertarian or secular discussant of or advocate of religious liberty. I don't go to church. I don't, or synagogue. I don't. I guess I'm kind of Jewish, right? But I think these issues are so important because, as Mollie said, religious liberty is the canary in the mine shaft. If the rights of conscience, if the freedom of will is not observed, well, then you get to the gulag. I think Alexander Solzhenitsyn has influenced my thinking on these issues just as much as anyone who, through his historical novels, just as much as anyone writing specifically on legal or religious history issues. And so what I want to talk to you about in the few minutes I have is how modern battles of religion in the public square are a microcosm of the constant tension between civil society and an overweening regulatory state. In other words, my concern with religious liberty isn't so much religious liberty itself, but that it's a wedge into all the rest of our liberties. As Megan McCardle, who's a columnist at Bloomberg View, noted after the Hobby Lobby ruling, these cases, and she was talking specifically about contraceptive mandates, but you can apply that to Masterpiece Cake Shop, the wedding vendor cases, a whole host of things that we've heard about in the last decade or so, present the unusual situation in which both sides think that someone else's views is being imposed on them. How can that be? I mean, normally in political disputes, the debate is over the economic and moral justifications for a particular policy, or whether the regulatory benefits outweigh the costs. But here, one side says, for example, that not paying for contraceptives is equivalent to imposing religious beliefs, while the other says that the coercion lies in being forced to buy something that you don't want to buy. Now, we can argue whether it's a good idea to require people to buy certain goods and services, but it's pretty clear that Obamacare, or at least the regulatory mandate, forced employers to do so. An exemption from a mandate seems hardly coercive, and such an exemption would harm third parties only if we think that those third parties have a right from the very beginning to force others to pay for their goods and services. And so again, that is the problem. It's not that either the Little Sisters or Hobby Lobby or wedding vendors started all of a sudden discriminating against people or otherwise harming them. It's the government essentially created the nuisance, the burden that then accelerated the clash. The left's outcry over all of these religious free exercise cases is evidence of a more insidious process where the government foments social conflict as it expands in control into areas of life that we used to consider public and not governmental. Americans have become so used to government providing all manner of goods and benefits that resisting state action begins to look anomalous. We have to fight for every carve-out of freedom from a regulatory sea of authority. And this conflict is exceptionally fierce now because the long compromise that seemed to have been worked out between the state and religious groups, that is, do what you want within fairly broad limits, but don't expect the state to promote it, is breaking down in the face of a shift in the way that we view rights and the way that we view the role of government in public life. And so it's the government's relationship in public life that's fundamentally what's changing, not how religious believers want to exercise their beliefs. And so in places that are beyond the intimacies of the home, but still far removed from the state, like charities, social clubs, small businesses, even public corporations, these things that used to be considered part of the in public, but not public in terms of state action sector, what sociologists might call third spaces, what classical historians and probably Professor Eire is familiar with Chief Justice Matthew Hale's 1670 treatise De Portibus Maris, of the Gates of the Sea. Or maybe, no, you said your knowledge drops off at 1650. Well, this is 20 years after that. Anyway,
31st.
There you go. Well, there's three areas that he pointed out. The jus privatum, the private law, that's purely private things. The jus regium, that's the government's or the king's regulatory law, and the jus publium, which are kind of the civic or social realm, and in modern times can be seen as true public accommodations or common carriers or what have you, monopoly situations, whether government granted or market or natural monopolies, in which case we have special kinds of regulations over public utilities or common carriers or what have you. But we don't generally think of private businesses as being in that space where the government effectively doesn't necessarily nationalize it, doesn't take it over itself. We're not talking about this is necessarily communism, but regulates in such a manner that in effect it's the cat's paw of the government action. And so through an ever-growing list of mandates, rules, and statutory positive rights, the government is regulating away the little platoons of our civil society, which civil society is so important to America's character. Yet being smothered by the ever-growing administrative state that in the name of fairness and equality takes away rights in order to standardize American life from cradle to grave. And so what we've been seeing is just the latest example of the difficulties inherent in turning more and more parts of our economy over to the government. It's a larger, more destructive trend enabled by the Supreme Court's ratification of expansive federal power, to effectively through mandates and regulations, not so much taxing and spending. That's a separate issue of taking over civil society. The assumption underlying this trend is what former Representative Barney Frank told the 2012 Democratic National Convention. Government is simply the name we give to the things that we choose to do together. Well, the major problem here is that when something is socialized or treated as a public utility, then we are forced to fight for every carve-out of individual will or conscience or liberty. So the more that we, quote, choose to do together through the coercive hand of the state, the less that we can do in our private capacities, either really together or separately. Government has recently moved past the conventional crowding out of civil society by, say, getting involved in welfare-type organizations that their money crowds out, money that would otherwise go to private charity or education or what have you, instead now narrowing the rules of the game such that private institutions are allowed to continue operating only if they follow a prescribed list of mores. And so the goal seems to be to force any religious believers, whether employers or businesses or private individuals, to conform to the we're all in it together ethos, my way or the highway, because there could have been lots of compromises, lots of exemptions at the regulatory or legislative stage, but the way that these mandates have been enforced, progressives have not been interested in that. And I think they fail to appreciate the precedent that sets, because through this kind of excessive regulation, government stymies individual conscience and voluntary institutions of civil society in ways that don't necessarily go in one particular direction. I mean, as I like telling my progressive friends, why is it that you want Donald Trump and, for that matter, Scott Pruitt at the EPA and you name it, Rick Perry at the Department of Energy? Why is it that you want them to have more power? I imagine you'll hear more about that subject in the last panel on the administrative state. And at the same time, political appointees and bureaucrats also prefer this method of power dealing because they gain prestige and influence to hand out favors and indulgences, one could say, of the modern regulatory religion. And this growing enforcement of a centralized ideological conformity is the real innovation that we've seen in the use of government power in the last couple of decades. And so many of our culture wars, I think, are a direct result of government trying to force one-size-fits-all policy solutions onto a diverse nation. I think a lot of our problems, whether that involve religious liberty or otherwise, could be solved with real federalism. There's no reason why a contraceptive mandate has to be the same for Texas and Florida and California and Maine and Nebraska and everywhere else. The more that you can practice another kind of religious concept, to borrow another religious concept, subsidiarity, going to the most local level possible, the less of these tensions that you're going to have. Instead of concluding from Justice Ginsburg's list of hypothetical parade of horribles of what would happen if lots of people got exemptions from mandates, that nobody should get exemptions, the more obvious solution to me would be to allow everyone to have the same freedom to choose how to live his or her own life. And so rather than, or more than just a RFRA, a Religious Freedom Restoration Act, we should have an ORFA, an Omnibus Freedom Restoration Act. Whenever government burdens your liberty in any way, it has to prove that it is absolutely necessary and there's no other way of accomplishing a really important goal. Anyway, that's where I stand. I mean, we largely agree, at least within reasonable margins, that certain things are collective needs that fall under the purvey of the federal government, such as national defense, basic infrastructure, clean air and water, and a few other such public goods. But we fiercely disagree about social programs, many economic regulations, and so much else that government now promulgates precisely because these things implicate individual freedoms. The trouble is that when government grants us freedoms, or is seen as granting us freedoms, instead of protecting them, the question of exactly what those freedoms are becomes much less clear, and every liberty we thought we had is up for discussion and debate. So those of us who supported the religious believers in whether the contraceptive mandate cases, the wedding vendor cases, or anything else, were rightly concerned that people are being forced to do what their deepest values prohibit. But that's all part of this new collectivized territory.
Great.
Thank
you. Now, part of my job is selecting from the audience who has questions. There are microphones. Are there microphones on both sides, or? Okay. And I have to point out, there's a bright light on me, so I may have trouble seeing the hands as they go up, so wave as vigorously as you can if you're towards the back, please. Hands, questions? Yes, right here in front.
I got this bizarre email from the Yale Club inviting me to an evening where I would listen to the Yale Divinity School prove how morally superior they were to Hobby Lobby. And I don't know any of the background to it. I just was curious whether you, and I sent a nice note back, which I'm sure resulted in my being removed from their mailing list. But whether there's some color on this and what's going on and why the Yale Divinity School is dedicating their resources this way.
Well, I'm not at the Divinity School.
Well, if the Yale Divinity School isn't more moral than a hobby, than a profit-making corporation, we're in trouble.
Bad news. Really bad news. We're in trouble. Just kidding.
Maybe it's because they spend all of their time, glorifying Jesus Christ and staying out of politics. That's what divinity schools are for, right?
There is a very thin line between orthodoxy, religious orthodoxy, however it's defined, and political orthodoxy. And depends on where you are, which divinity school you're at, which church you belong to, where that line is drawn. But political correctness, right, in some places equals religious correctness, orthodoxy.
I do want to make, oh, sorry.
Go ahead.
Just one point on this, too, that I think is worth noting. Groups that have established theologies or great legal basis, corporations, religious denominations, churches, pastors, they do pretty well in religious liberty battles. The people who don't do so well in religious liberty battles are just the independent Sikh, Hindu, Christian, who's going up against the state, but they're just an individual. They don't have the backing of a major religious group or the legal resources that go with that, too. You look at a case like Baronelle Stutzman, who has just suffered mightily. She's a florist in Washington State, served the same gay customer weekly for 9 years, became friends with him, grew to love him. He asked her to do the flowers for his wedding to his male partner. She gave him a hug, but told him that she couldn't do it because it violated her conscience. She stands to lose her business, her home. She's been sued by the state of Washington and the ACLU, that valiant defender of liberty, the ACLU, and everything's on the line. But she's not a religious institution. She's just a lady who has the right to practice her religion. And, you know, a lot of the cases that we're seeing, like Jack Phillips, is that his name? Which is the case that's coming up in this session. You know, he's a cake baker. He declines all sorts of cakes. He is so pious, he won't do cakes like to mark a divorce. So if someone wants to come in and celebrate that their marriage is ending, he won't do it. Bachelor parties, Halloween. He also declined to do a cake for a same-sex ceremony, and his case is going to the Supreme Court. But he's just a guy. So this is another problem that we have in terms of the assault on religious liberty. We might be pretty good when it's a Lutheran church, which has systematic theology and whatnot, but not for, you know, a random evangelical.
Great. Another question. Yes.
Thank you. Great panel, great discussion. I was wondering if you could comment on, as far as the threat on religious liberty, the tension from the Equal Protection Clause and the anti-discrimination push, because all these laws that are passed against the bakers and the other vendors are under the rubric of anti-discrimination. And we saw that, you know, there's a clause in the First Amendment about freedom to associate, which also meant freedom to not associate, which meant you could exclude people. And that no one talks about anymore. It just seems to have disappeared because the culture has moved. And so the cultures, you know, law does affect culture. It's not just simply, you know, it comes up. And I just don't know what the strategy is so that what happens to religious liberty doesn't happen to the other clause of the First Amendment when it's up against another provision, another section of the Constitution that has the force of culture and political correctness as everything is behind it.
The short-term strategy is to run whatever you can through the free speech clause, and the free speech argument is much stronger in the Masterpiece Cake Shop case than the free exercise clause argument. But when you're talking, and indeed, if the argument devolves at the Supreme Court about whether baking is sufficiently expressive, that's great. I do want to establish the standard that the free speech clause protects you against all sorts of mandates. And if we're quibbling about whether floristry and baking is on which side of the line, you know, that's better than saying there is no such principle. You can even force, you know, publicists or singers or photographers or what have you. The larger issue that you raise is that our conception of public accommodations is completely out of whack. If you look at, there are a couple of, well, more than a couple, but two that I'll point to, very good amicus briefs on this in the Masterpiece Cake Shop case. One is by the Thomas More Legal Society, and one is by the Scholars of Law and Economics, actually, about the meaning of public accommodations under common law, that it was traditionally an inn, a place you stay overnight or have food. Otherwise, travelers would have no place to go. And in effect, you have a natural monopoly of that sense. There's some parallel there to why public accommodations, anti-discrimination laws under the Civil Rights Act of 1967 are justified, not under some crazy Commerce Clause regulatory expansion, but because of both state-supported segregation and kind of a social pressure that functions effectively like a monopoly circumstance, you would have the same effect with black travelers and others. And so that can be justified as a manner of helping their the true civil rights. But when you have something like, I forget what the statistic is, something like 60 bakeries in the greater Denver area that, not just bakeries, but specifically advertise same-sex wedding cakes, when the closest one to Masterpiece Cake Shop is 1/10 of a mile away, it's certainly no burden to say, okay, we'll give this guy an exemption. Don't force every last dissenting view because there is no emergency situation. There's no, your feelings might be harmed somewhat, but if you're doing a Google search, it's not like you're randomly walking down the street going into bakery after bakery. You're doing a Google search for bakeries. Which one's closest to me? Which one has done good cakes that I like, or something like this. And it's certainly no burden to say, find whatever, whichever one you want to go to and go to that, and it doesn't mean forcing everyone. And so that's a kind of a nuanced and historically more correct understanding of public accommodations protections and the freedom of association for that matter, but that's been lost. And frankly, I think it's disappointing to me that a lot of the supporters of Colorado in this cake shop case that would force the baker to bake the cake are making a parallel argument to Jim Crow. I think that really slanders the heroism and the bravery of the civil rights era challengers to state-sponsored segregation.
Another question.
Sorry to drone on. I have some strong feelings on
We'll go to this side now, over here. In the middle? Yes. Yeah.
Hi. So this is primarily for Professor McConnell. I just finished my law review note a few months back, and you're about half of my sources. So one of the points I make in that article is that the way in which these test cases are done, where people are going after bakers or whatever the case may be, one of the axioms in free exercise jurisprudence is that you can believe whatever you want. Jonah Goldberg's old, the left won the culture war, and what they've been doing is roaming the countryside.
That's John Gabriel. John Gabriel said that.
Oh, was it? Mm-hmm. Okay.
It's okay.
It's funny. I thought I heard that on the Federalist podcast, so I'm not going to blame him. But yeah, if freedom to believe is axiomatic, and these test cases are going after people, specifically to find people who just disagree with the orthodoxy, is there any legal way to address that? And second question is, I appreciate your appreciation for RFRA. My question is there any stronger constitutional protections in case RFRA goes away that can be enacted to protect it even better?
That's a good question.
So we have to fight with the legal tools that we have. You mentioned, freedom of belief. You look at the First Amendment. There are 6 different freedoms protected. There is free exercise of religion. There's the non-establishment clause. There's freedom of speech and press and assembly and petition. Now, you might say, well, that all those have to do with belief, and indeed they all do, but those are the 6. And so we tend to, in terms of actual bringing cases, we try to fit people with beliefs into one of those categories. And that's why the best shot for the Masterpiece Cake Shop people is, in fact, freedom of speech, not really freedom of belief. They're being forced to do. It's actually a freedom of speech case in 2 different dimensions, and I think the briefs have not been good at capturing this. There's the speech of making the cake, which is itself, there are messages involved in a cake, and they're similar to photographers or wedding singers or other expressive activities, right? And they're being forced to convey a message that they don't believe in, and that's compelled a speech. But there's another kind of speech going on too, and that's the wedding ceremony. What is the wedding ceremony? It is an expressive assembly, right? It's a meeting of people expressing something, And so in addition to the cake being expressive, the wedding is expressive. And I think a genuine civil libertarian would invoke another principle, which is that no one can be compelled to participate in an expressive assembly that they don't choose to support. If this is so, it defends not just the expressive categories like bakers, but what if you're a janitor and don't want to lend your support to a ceremony? Like, let's imagine that you're a janitor and the Ku Klux Klan meeting is asking you to come and clean up afterwards, and you say, no, thank you, I don't support what you do. Or let's say you're a Jewish janitor and you've been asked to be hired to clean up the Catholic Church, and you say, as many Orthodox Jews believe, they do not go inside Christian churches because of, we won't get into why, but they don't go inside of Christian churches, and they have a right to do that, right? So the speech, I think, is actually a very powerful protection on both sides. Why is religious freedom probably not going to be part of the Masterpiece Cake Shop case? And the reason is that it's a state law. The Free Exercise Clause, which applies to the states, was gutted in Employment Division versus Smith. The Religious Freedom Restoration Act applies only to the federal government, thanks to yet another Supreme Court decision. And Colorado has not enacted a state-level Religious Freedom Restoration Act, so we really don't have any tools. We don't have any legal basis for protecting religious freedom as such in that particular case. Your last question, is there some better way to do a constitution? I don't know. Actually, I think if you think about those 6 freedoms in the First Amendment, they were carefully chosen because they respond to all of the major regulatory attacks on expressive activity as of 1791. Maybe we could improve upon that, but I just say let's enforce what we've got. It reminds me, was this Mahatma Gandhi or was this Jonah Goldberg who said, who was asked what he thought of the United States Constitution, and his response was, it would be a good idea.
We have time for one more question over here in the center, this side over here.
Thanks. Great presentations all. My question is, in seeking to understand some of the forces and pressures behind these several legal battles that you've eloquently discussed, is it useful to suggest, as some have, that what we're really witnessing on the left is its transformation into a kind of secular religious substitute, and that what's really going on here is almost a tectonic battle between a secular pseudo-religion and traditional religion, almost akin to a modern version of what happened in Europe several hundred years ago? And if so, how does that help us find resolutions?
So Mary Eberstadt wrote a great book on this. Does anyone remember what the title is? I think it's her last book, which are... It's not. It's after that. But it's specifically sort of on how sexuality has become a new religion, and we're forming doctrines, and they're even changing. Like, we're in this really robust period of hashing out what the doctrines are, and once you think you've got it, actually it turns out you're totally bigoted for having held to that because it's moving on. And it has this new religion has heretics that must be burned, it has high priests, it has ways of worshiping, and once you kind of see it that way, everything becomes really, it all kind of clarifies. Even our current religious liberty battles, so many of them are about whether this sexuality religion, which has, sort of sacraments, whether it's abortion or contraception, and you can't violate those things, you start to see these battles a little more clearly as religious battles, and you realize you're dealing with very devoted, fervent worshipers, as opposed to a different type of opposition.
But so the question is, why might this be a useful way to think about it? And it's not, I don't really think it's particularly useful to point a finger, oh, you're just being religious. Frankly, I'm religious, and it's not an insult to say that they're being religious. False religion, but that's another story. The reason it's useful is because we have a constitutional framework of free exercise and non-establishment. People who believe in this new religion are, in my opinion, entirely free to exercise it on their own. What they are not free to do is establish it as the official doctrine of the United States. And that's why thinking about it in these terms, I think, actually is illuminating.
Yeah, if we had modern-day Aztecs, we wouldn't allow them to perform human sacrifices because that impinges on others' freedoms and rights. And so, similarly, if this is a modern religion, then that's fine. You can make sure that all of your homes and businesses are properly have trigger warnings and safe spaces and don't microaggress, and that you label everybody, including your dog, with their preferred pronouns and all these other things. But you can't force someone else to do that because that violates their natural rights in turn, and that's fine.
Yeah. Well, we've run out of time for this session. I just want to add one thing to this last question, which is, in fact, that religion is often misunderstood in discussions of belief, because belief is often reduced to an internal abstraction. You believe something, that's protected. But religions are not just beliefs.
Practices.
Symbols and rituals. Beliefs have, religions have codes of ethics and behavior. And I think in regard to your final question here, yes, it cuts both ways. You've got certain behaviors now that are being prescribed for everyone, but also at the level of belief. A belief is a belief. A political belief is hardly different and at times indistinguishable from a religious belief. And that's where we are at the moment. So, we'll solve more problems the rest of the afternoon. Thank you. Thanks to panelists.